In Unit 7, we discussed the estate planning documents needed to support your legacy to your loved ones. Even if you have those documents in place, you must review how you have titled your assets. When you open a financial account, you buy a car or home or other asset, you're going to be asked, how would you like to title this account? This seemingly simple question has major consequences at your disability or death. Even with the best financial plan, the best trust documents, the will, the power of attorney and such, even with all of these in place, if you've titled your assets or your beneficiaries incorrectly, these documents will have little use to you and your loved ones. Let's start this important discussion with a trip down memory lane. Remember the Ringling Brothers and Barnum and Bailey Circus? The one I went to had 3 circular areas on the circus floor where performers would display their tricks. My favorite was a flying trapeze show. You remember the one where the performer would be on the left-hand side and swing out, and then there'd be one on the right-hand side that would time the swing and so they could catch each other. Well, there were twists and flips and death-defying jumps, and it was great. And if one of those stunts missed and the performer would fall, they would be caught by the net. And even that fall ended up being theatrical at some level. Well, with the trapeze in mind, I want you to picture that when someone dies, all of their assets start falling towards the net. If there's a named beneficiary like your IRA, then the trapeze will fly out there and grab your IRA account and hand it to the beneficiary. Same with the 401k or the beneficiary on a life insurance. They're going to swing out there, grab that account, and give it to the named beneficiary. If there's a transfer on death designation on an account, the performer will swing out and grab that account and do the same thing, hand it to the beneficiary. The same thing occurs with joint accounts. For assets named into a trust, the performer will swing out there and grab that as well and put it inside the keepsake box before it's locked and shut. Eventually, the flying trapeze performer will grab all of the different assets designated to go somewhere. When the remaining assets are not grabbed away, they will fall to the net. In this example, the net is the will. And all of the assets transferred to beneficiaries will happen before the will. So many of my former clients used to think that the will governs all of their assets. This is not true. It only governs the assets that fall to it. Others think that they don't have to worry about a thing because they've created a trust. That's not true. Only those assets titled into the trust will be governed by it. Without thinking about it, all of the assets that we have are somehow owned by each of us. From the informal ownership of our personal goods like jewelry, TV, furniture, and clothes, to the formal ownership of the title of your home or your car or your checking account or your brokerage account. These assets are owned by us, and at our death, these assets will become owned by our survivors. In my many years of financial planning, one of the most overlooked aspects of owning assets is how they are titled. When you go to the bank, you often don't give any thought to the banker's question, how would you like to title that account? No matter how much thought you put into the answer, how you answer this seemingly innocuous question has significant impact as to how that account will be handled at your incapacitation or death. So here are some ways assets are owned and how they will pass when one of the owners dies. I want you to pay particular attention to this as you might want to revisit your own ownership options after having a better understanding as to how they will transfer to your loved ones. The most common titled asset among married couples is joint tenants with the rights of survivorship. This method of titling can be used with a parent and a child, with business partnerships, or other relationships. As the title suggests, joint ownership means that both owners have an unlimited right to withdraw the money, and the survivor will receive all of the money at once at the time of the other person's death. Joint tenants with rights of survivorship bypasses the probate process, and by operation of law, this asset is immediately available to the joint owner, regardless of the value. Joint ownerships are not governed by the will or the trust. Joan was a widowed mother of 3 daughters. Her estate was worth approximately $900,000, and $600,000 of it was liquid. In other words, in a variety of cash or near cash holdings such as CDs, money market, savings accounts, and checking accounts. The $300,000 remaining was in the value of her house, the car, and some personal items like jewelry. To avoid moving to a nursing home, Joan moved in with her daughter, Lisa, who lived nearby. The other 2 daughters lived across the country with their families. Out of convenience, Joan titled all of her banking assets in joint name so Lisa could easily effect any changes, renew CDs, and write checks should Joan become incapacitated. Therefore, $600,000 was in joint accounts. Joan had a will that divided all of her estate equally into thirds among her 3 daughters. Unfortunately, this is not what happened, and the legacy that Joan wanted to leave did not come true. I want you to think about that Trapeze Act that we talked about a second ago. When Joan died, all of her assets were poured towards that net. Well, one of the performers swung out there and collected all of the joint accounts and came back and handed them to Lisa, who was the joint owner. Because the house and the car were titled in Joan's name only, they didn't get taken away. Instead, they fell and hit the net. Additionally, all of her personal jewelry also landed and hit the net. Everything was sold, generating about $300,000 in cash, which was all put into the estate account. As the estate account is governed by the will, and the will said to split evenly, each daughter received her third, or about $100,000. So Lisa received $700,000, and the other 2 received $100,000 each. This was not what Joan had intended. At the end of our class, we're going to discuss a solution to how Joan could have handled this better. But let's cover some ways that are the most common ways to title assets and the things that you own. Tenancy in common. This titling is used when 2 or more people own the account. They can be related, like a husband and a wife, or a father and a son, but they need not be. Each owner owns a proportionate share of the account value. Because each owner owns his or her own share, each person has the right to sell their share, give it away, or will it upon their death. This is governed by the will. Tenancy by the entirety. This account ownership is only available in certain states to married couples only. Neither owner can dispose of his or her half while alive without the permission of the other owner. Upon the death of the first, then the survivor becomes the sole owner. The will and the trust do not govern this account. Single name. As the name suggests, accounts in single name are yours only. These accounts become part of your estate and are not governed by the trust. They are governed by the will. Transfer on death and payable on death. If you have a single account, you can often add the transfer on death designation. This transfer on death title will transfer your asset at your death to that named beneficiary. While alive, the named beneficiary has no access to the money and is not even entitled to being notified that he or she is even named on the account. At the death of the owner, this account will transfer directly to the named person. In some states, the designation is POD, payable on death, and this performs the same function. So TOD accounts are available at most deposit institutions, most brokerage accounts, and other accounts that deal with money. Because you name the direct beneficiary, transfer on death accounts are not governed by the will. Property can be titled in the name of a trust. These accounts are governed by the trust and not by the will. The executor and executrix has no authority over these accounts. Only the successor trustee will be able to settle trust accounts. Trusts are powerful legal documents that help with the flow of assets in a specific direction under certain conditions. The trust can also be used to capture important tax savings. Look for a more complete discussion on trusts in one of the other bonus tracks. Accounts with beneficiary contractual investments, life insurance, annuities, and retirement plans like IRAs, 401ks, 403bs, SEPs, Roth IRAs, KEO, simple IRAs, 457 plans, pension plans. All of these allow you to name a beneficiary, no matter what the will says. If no beneficiary is alive, the money will transfer to the contingent beneficiary. If neither the named or contingent beneficiary is alive, the money will then fall to the estate and transfer through the probate process according to the will. Titling will determine how assets transition at death and which document governs that transfer. Your estate planning documents and the way you title your accounts will be one of the most important components of your financial plan, while alive or at death. You can work hard at earning money, creating it through investments, safeguarding it against bad decisions, but all for naught if you don't have estate planning documents in place or if your accounts are titled incorrectly. Please see your professional team to determine if your documents are updated based on today's laws and if they will indeed transition your assets and your legacy the way you intended. Let me give you a word of caution. There are cases when widowed mothers will jointly put their only child on account documents. Well, he's going to get it anyways, you might think. So the mother and the son create joint accounts. This means that the mother and the son own all of the assets, and either one of them can withdraw all of the assets at once without the permission of the other. Well, if the son gets into any trouble at all, like a divorce, a lawsuit, IRS trouble, for example, then his entire joint asset can be attached as an asset of the son as part of the son's amount of that judgment. Perhaps a better way to proceed is for the mother to give the son a durable power of attorney over these accounts and have the account titled TOD, or transfer on death, to the son. The mom could also create a revocable trust. This way, if the son experiences any trouble, he doesn't own the assets. Therefore, it cannot be attached in a judgment. At the mother's death, the transfer on death will transfer it to him and bypass the probate process. Do you remember the mom who had the 3 daughters at the beginning of our lesson today? Joan had created joint accounts so Lisa could help her manage her money as Joan got older. Well, this situation caused a lot of problems with the three sisters and could have easily been avoided if 1, Joan had given Lisa durable power of attorney to help her with the bank accounts, or 2, Joan had placed on her accounts a transfer on death to her 3 children, which would have bypassed probate, or 3, Joan had put the assets in a revocable living trust and named her 3 daughters as equal beneficiaries. And by now, you know that the trust would have also bypassed probate. Any one of these 3 options would have ensured Joan's wishes would have been followed. Well, now that you know, check the way that your accounts are titled. Don't make the same mistake as others while you create your legacy.